Hello, everybody, and welcome to the Memes Are Illegal Intellectual Property 101 panel. My name is Noah Downs. I am kind of the moderator person up here, as much as we have a moderator person. I just said in as much out loud.
Killing it.
God. So real quick before we get started, wanted to introduce our panelists or let them introduce themselves. First, we'll start off with Ryan Morrison.
Hello. I speak here every day and I commit defamation against LegalZoom. I am a lawyer. I run a firm called Morrison Rothman. We've been representing indie game studios for over 5 years now. And I run a talent agency that represents a bunch of pro players in esports and Overwatch, Fortnite, League of Legends, etc. And games that I like that no one plays like Dota. And I go by Video Game Attorney on Twitter and Reddit. And there you go.
Cool.
And memes are illegal.
And then we've got William Nixon, or Bill.
Yeah, Bill. Hi, Bill Nixon. I'm a patent attorney. I'm trying to think. I'm not quite as cool as Ryan over there.
He plays Dark Souls.
No one is.
I do play Dark Souls and Bloodborne. Let me try to think. In terms of gaming and patents, I was just joking up here. Really, it's gambling. For whatever reason, I seem to be getting gambling clients, online gambling versus actual gaming. So I'm hoping to get a real gaming client because gambling to me is gambling, you know. But Anyway, we'll talk a little bit more. But if you have questions afterwards about the patent process, the government, even though it's shut down, issued new regulations this morning on patenting software. So
that's why we're all in D.C.
Yeah.
We're going to fix this. Maryland, sorry, I don't know where we are. All right, before we start though, can everyone flip me off, and I'm going to take a picture of it and tweet out that I said memes are illegal. So everyone just flip me off. Thank you.
Cool. And I am Noah Downs. I'm an attorney based out of Richmond, Virginia. Hey!
I didn't mean for the whole panel.
Literally my client. I'm an attorney based out of Richmond, Virginia. I'm also a video game lawyer, not attorney.
I don't own an attorney.
I know. I do all sorts of stuff from representing influencers to indie devs and everything in between. And so without further ado, we're going to start answering your questions before you ask them. So, what is intellectual property anyways? Does anybody out here know? Don't answer that. Ryan, what's intellectual property?
It's the property of intellectualism. Yeah, I mean, in all seriousness, when I went to law school, I wanted to do criminal law or whatever I was going for at the time, and I had no idea what the difference between a copyright and trademark was or at all. And I know from the questions I get on Reddit or Twitter or elsewhere that you guys don't either, but you don't need to. I mean, it's understandable. Why would you know that? I know very little about programming, so I don't expect you to know a lot about the law. But the goal of this panel is because a lot of you guys here are developers or artists or just creative types. You should know just the very basics of the laws that protect what you're making. You should know when you own something. You should know when you don't own something. You should know that fan games, despite what Reddit will tell you, are not okay. They're definitely infringing. Sega will sue you.
Super illegal.
Yeah, so we're going to run through basically the basics of the four main categories, which is...
We have patent. We have copyright and trademark. And we have trade secrets. Those are the four main parts of intellectual property. You have like subparts, but that's really too technical, and we're trying to keep it light and jovial up here because we're lawyers and we're known for our hilarity. So basically, what is a trademark? A lot of people confuse trademark and copyright. That's the main terms that we hear. What is a trademark, Ryan?
A trademark is the thing that protects your brand. So it's your source signifier is the legal annoying way to say it. But what that means is when you pick up a can of Coke, you know that is a product made by Coca-Cola. It's not something Travis made and put Coke on it. That's something very different.
That's cocaine. That's also illegal.
No, but in all seriousness, it's actually not there. Copyrights are there to protect you guys that are creating things. Trademarks are there to protect your consumers. It's so that when you buy a product from a company, you know you're getting a product from that company. You can expect similar quality, or even good or bad, you just know what you're getting. And I think trademarks are super important to utilize and remember when you guys are building your own brand. It's the first thing that gets stolen. Everyone's worried about cloned games or cloned art assets or everything else, but it's so easy to change your name by a letter or something else and go just steal your entire fan base. more dangerously, when you come out with let's say you've come up with a studio name, it turns out someone else already had a studio name that's very close to that. You didn't do a proper clearance because you don't know how, and now all of a sudden you're getting a cease and desist months or years later, and you have to start from scratch on marketing and everything else. The simplest explanation of trademarks is McDonald's, because trademarks are many things, but two main things. It is the name McDonald's, and it's those golden arches. So it's your name and your logo are the two main forms of trademarks that I normally recommend you guys register, names being more important 90% of the time. If you can only afford one, we know budget is a thing. Yeah, so it's super important. The question that I know we're going to get asked 30 times, so I'll just answer it now. When you should trademark something, let's say you're just coming up with a studio, you have an idea, you haven't quite made the game yet, but you're working on it, or quite haven't released the game, but you're working on it. Trademarks are not like copyrights. Copyrights, as Noah will explain, you register after something's created. Trademarks you can file with an intent to use that name. So if you come up with a name you really like, you file under intent to use. That doesn't in and of itself give you any real protection, but once you actually enter commerce, that protection will backdate all the way to when you put that application in. So it's actually good to put it in early and kind of secure your name. And that's the quick rundown on trademarks.
And just to kind of get a little weird out here, you can actually trademark other things too, in addition to name and logo. You can trademark sounds, you can trademark smells, you can trademark particular colors or patterns.
Slogans, ba ba ba. I'm loving it. I don't know why all my examples are McDonald's, but I'm going to keep that going.
Are you hungry?
Yeah, I'm starving.
Somebody get this man a McDonald's.
I don't even want McDonald's. Is there Taco Bell in Maryland?
I just had some of that Elevation Burger place. That was awesome. And so, but yeah, so you can trademark those other things too. Like Ryan said, what you're going to want to focus on is the things that are inherent to your brand, and also keeping an eye on your budget for when you're starting up. A lot of you out there are startups, and you're trying to get out there and secure your piece of the pie. So make sure you're careful with that. One of the examples of just changing a single digit in a name, I've seen there's a YouTuber named H2O Delirious. I don't know if anybody out there is familiar with him. There's 1.5 million H20 Delirious accounts out there. And it's just driving him absolutely insane because none of them are him. He's actually verified if you do follow him. So.
Yeah, and we're not going to get into the deep of it, but even myself, Reddit started calling me video game attorney, and I ran with it. 3,000 other lawyers started going on Reddit making their usernames the video game attorney, video game attorneys. It was nonstop. Now, video game attorney is descriptive. I would never claim ownership of it. I'm not protecting it, and we're not going to get into the kind of exceptions to exceptions to exceptions. But replace video game attorney with your studio name, and you spend all this time, money, and energy marketing it. Don't let someone come in and steal it by changing it a little. With you having a trademark, you are protected against anything confusingly similar. And when the government thinks about what is confusing, they think of your dumbest friend. So if your very dumbest friend would be confused between those two names, you're probably going to be protected.
Am I your dumbest friend?
You are, no.
So, Bill, I didn't know if you had anything to talk about with trademark, Mr. Patton.
No. That's the fun part
See
of the
that dark
law.
space over there?
That copyright, trademark, that's fun. It's neat. It's cool. Does anyone here even care about patents at all?
No.
Yeah, come on.
Okay.
Cool.
Okay.
So I'm going to pop it over to copyright real quick, just give a basic overview of that. So with copyright, copyright is anything that is fixed in a tangible medium of expression.
Nerd.
So basically, anytime you draw a smiley face on a napkin, you have a copyright in that smiley face. It's very pretty, probably not. And so you can see where that can get really confusing, and there's probably a lot of copyrights out there. However, you can really only enforce those rights if you register with the Copyright Office, so hire us. Anyways, but there's a lot of different aspects of copyright. It can be used for a lot of things. It can be used for music, it can be used for art, it can be used for anything, video games, software, what have you.
Yeah, in the world of video games, it's your
main
script,
thing.
art, everything.
Yeah, and so when you're creating your content, you have a copyrightable interest in that content. However, you can't enforce that until you really have registered with the Copyright Office. At least you can't sue somebody. You can still DMCA them. That would be a good time to hit the DMCA a little bit, wouldn't it?
You brought it up, so
Sweet.
You
So
can't
the
brag about your own segues.
I mean, I can, though. I'm up here. So the DMCA is the Digital Millennium Copyright Act. Essentially, it is, as Ryan said yesterday, it's one of the best things that Congress has ever done for tech. It allows people to enforce their copyrightable interests without having to sue people for millions of dollars, at least at first. What it happens is if you create content, somebody rips it off. You see it on YouTube, and you can issue a DMCA notice to YouTube or Twitch or to wherever it is. Twitch, YouTube, etc., is required the minute that you submit that DMCA takedown notice to take down that content. However, the person who uploaded it can counter-notify against you if they think they have a legitimate, honest reason that they own that content or have a right to use that content, say you licensed it to them or something. And at that point, you do have to sue them. But when you submit that takedown, you're doing a couple of things. One, you're showing that you actually do own these rights, which is awesome because you've created that wonderful art. Two, you're swearing under penalty of perjury. How many people know what perjury is? Cool, great. You probably saw it a lot in the news lately. So, what basically perjury is if you lie.
Because of Hillary's emails. Just kidding. Kidding.
Okay, I need a second. Anyways.
Too soon.
No memes.
I still think I'm in a fever dream and she won. So
That's right, baby.
So, anyways, God, we're not out here to crush their souls, guys. But when you swear in a penalty of perjury, you're basically saying that under the threat of criminal prosecution, which means going to jail, that you have a right to that content. It's your content. The person who counterclaims against you has to do the same thing. So if they're lying, that's bad for them. You see a lot of false DMCA strikes nowadays, and that's a problem. And honestly, the practical side of that is that if you have content that you've uploaded and somebody wants to take it down and they have more money than you, they can basically bully you.
Right.
And so that's an abuse, and hopefully there's things down the pipeline to fix that.
Yeah, and I just want to add in on the DMCA, it forever intellectual property was the land of kings. People hear DMCA and they think all the negative stories you're hearing about it constantly, but 10 years ago, none of you could make a game and get it out because some big company would come and steal it. Everyone would rip off each other's content, and unless you were very, very, very wealthy, it costs 6 figures to litigate something, usually minimum, you wouldn't be able to do it. So now the Congress basically said, all right, the internet exists, there's too much stuff being stolen back and forth, handed around, how do we fix this? And they came up with the DMCA takedown procedure, which is honestly a great step forward. The problem is the trolls that existed in the past are now just a different breed of trolls. There are people who take things down completely frivolously, knowing they're doing it frivolously, or they do it without knowing what they're doing, which is no excuse, because not knowing the law doesn't mean you don't know the law. And people counter notifications thinking, what I did is fair use, even though it's absolutely not fair use, which we'll get into later. But both parties are potentially committing perjury, which is a jailable offense. You can ruin your life. Now, for the past 10, 15, 20 years, the video game industry has been the kids in the kiddie pool hitting each other with the rubber noodles, and no one cares. There's never been someone who's gone to jail over a DMCA. That will change. There is too much money now. The game industry has officially now started making more money than music, movies, and TV combined. We're no longer a fad. We're no longer a joke. The 80-year-old senators that are retiring are being replaced by people who play Fortnite. Yeah. But in all seriousness, we're entering a stage now where this shit's going to be taken so much more seriously, and the idiots that are doing, you can see it with swatting. Swatting happened. Somebody died. All of a sudden now swatting, you go right to jail, and it's happening constantly. DMCA abuse is going to be treated very similarly, where maybe not jail, but life-ruining judgment and fines for sure.
Yeah, exactly.
Rant.
Rant, and that's actually a good segue into fair use right there.
We'll talk about patents.
Let's talk about patents. We're gonna get patents.
I tell you, I can't compete with the joy and the enthusiasm.
Tell us about patents,
but I legitimately know nothing about patents.
That very few people do.
I know enough to tell people to call you.
Yes.
Yeah.
Yes.
But I've told most people in this room and Twitter and Reddit that, in video games you don't really worry about patents. The quote I usually say is, it's like getting struck by lightning. If you get hit with a patent suit, it's life-ruining, but the odds of it happening are so small that it's hard to worry about. So I know that I'm wrong, so explain.
Okay, sure. Well, first of all, let me say, intellectual property definition, I always look at it that few people start a business saying, I want to do what that guy does, or I want to do who my employer does. You do it because you have some creative spark, whether you have better service, a better product, better content, whatever, better experience. And to me, that's what your intellectual property is. And you don't necessarily have to get a patent or whatever on it. You probably do need trademark and copyrights. They're really not that expensive, and you probably do need to get them. I know they're over there grinning, right?
Not cheaper than
me. But patents are a big deal. What Ryan's talking about is, yes, I send letters, and my clients get letters where they're doing everything they've done, things they've done for 20 years, and all of a sudden they get a letter saying, you better pay us $20,000 or we're going to sue you. From some unknown company in a P.O. box in Alexandria.
That's a lot of money.
Yeah. And, or it could get higher and higher. You probably heard patent trolls, things like that. And it is a way of life. Now, that does not mean, because we've kind of stared people down and said, we're not paying you. We can cuss, right?
Oh, yeah.
Okay,
Sounds
yeah,
like a
we're not.
sailor,
I'm sorry,
man.
I just had nose surgery. I'm all medded up, so we're not going to pay you shit because we're doing what we've been doing for 20 years, and we can prove it. And then the person might back down, or they might sue you, and you'll get a notice in the mail saying you've been sued. Then you really do have to come see someone like me and pay some money. It is kind of like lightning, but you do need to be aware of it. So what I tell people is you can do your own patent search if you want. There's a lot of tools out there online. You can hire me to do it. It's probably going to be a lot quicker, a lot better, and it's not going to be that expensive. And you can kind of see what you're doing, what's going on, and where you need to navigate so you don't get that type of letter. But some assholes are going to send letters no matter what. They're going to make up crap. They're going to go, we went to your website, we see you use a database, and we use a database, so now we're going to sue you. And you're going to say,
But
well,
that's not an exaggeration. We get, that's not an exaggeration.
And you're going to say, well, everyone uses these. Oh, we know you're bad. But you won't go to jail for patent infringement. You'll just go bankrupt. But the long story short is 50% of the time when I look at someone's patent portfolio, they don't own their own patents. They don't. Someone forgot to sign the paperwork. So that's a nice way out, pretty quick, pretty easy to say, you're asserting a patent you don't even own. There's some...
Can you challenge a patent? So for example, Zynga has a patent that is for starting a video game with money. So like if your character starts with gold, they own that patent. That's ridiculous. 9 million games do that. So if I got a cease and desist or a demand letter on that, what's the steps to telling them to go F off?
Okay, if you want to challenge the patent itself and say your patent's invalid because you pulled one over on the examiner, you had some slick patent lawyer like me come in the 11th. Let me, boom. Don't let. Are there any patent examiners in here? Oh no. Okay.
Any USPTO trademark side?
We haven't talked about patent prosecution, but that's mainly what I do. Patent prosecution is a negotiation with the examiners, okay? And sometimes things happen, things get through, and that's just the way it is. But you look at the patent, you look at the claim language, you say, no, this claim is 3 pages long. You probably have, what the hell, what do you mean claim, Bill? What the hell are you talking about? Imagine a deed of property that's 3 pages long, from here to there, over there, by the cow, by the river, this and this, this and this. You've got to meet every little element of that deed, right, to have the property. That's what a patent claim is. So if you don't have a cow down by the, or I guess it's a van down by the river, if you don't have a van down by the river in your invention, then you're good. You don't have patent infringement. So those are some of the things you can do quickly with an attorney, and you don't need to spend gobs of money, and you can rebut back. If it's a soft letter, you come back and go, you know what, we do what we've been doing, or the best one is, we do what your prior art says you've been doing. Now, what's prior art, Bill? Well, that's the stuff people have been doing since the beginning of time, okay?
Like fire.
Yes, okay. Yeah, I do what Atari does, okay? I don't do what PlayStation 4 does. So you say I've been doing this shit for 30 years, or this is technology that's been going on for 30 years. That's one way to rebut. Now, if you have unlimited resources, Unlimited. I'm
All right, so
talking
we don't need to do that one at
unlimited
MAGFest.
resources. Yes, there are procedural.
God moded it.
Yeah, there's government ways to invalidate patents, but yeah, that's up in hundreds
One
of thousands.
effective way I found was going on Reddit and Twitter and saying, "Look at this asshole company that just sent my client this letter," and then they usually go away very quickly.
Oh my God.
Well,
now, to be clear, that's Ryan doing that, not you.
No, yeah, you guys don't do that for real because you can very easily commit defamation. I'm happy to. So if you ever, and I don't charge for that stuff. So if you have I'm serious, if you have a legitimate problem where you know you got a frivolous cease and desist and you know you got a frivolous takedown, I'll help you for free. I will rub their nose on it because I love doing it, and I will do that forever. The problem is I get overwhelmed because that is a standing offer forevermore. My whole career started because of Candy Crush, trying to trademark Candy and Saga. I helped a lot of people with that for free, and I don't forget where I came from. You guys helped me build a law firm, so standing offer forever. But what you're doing is usually not fair use. What you're doing usually is copyright infringement, and that's what we want to get into. So don't send me that stuff, because that gets very... I made a Mario game, but I made Mario green and Luigi red. Get it?
Okay,
You know?
so we'll get into your weird Mario pronunciation in a second. But and to be fair, please do send him that stuff so he can defame people on Twitter, because I defend him from that stuff. So. And he doesn't charge you, but I charge him. So. But yeah, so that was an excellent summary.
Well, most patent trolls won't care if you defame them. They'll probably go, "Oh, we're proud of it." But yeah, I mean,
Well, most patent trolls are a shell company owned by a company
Yes,
owned by a
yes,
shell company
yes.
owned by a guy. I'll find that guy.
yeah,
He cares.
I'll find that guy.
But there are PR. I do have a client that I'm just going to leave it at this. There's a lot of heat and rhetoric going on because my client wants to, I guess, call out the other company. We in the PR arena, we want to make them look bad. Now I'm benefiting from it because
Sure.
they're hiring us, but that it is. See, you stole my invention. You're a bad company, and I guess there is a certain
Yeah.
In
I mean,
today's,
yeah.
social media world, that goes a long way.
because it's a very niche market of maybe a handful of players, and
Sure.
if one of them is known as evil,
right.
which the other side's always evil. Yeah, it's that could hurt.
I'm not anti-big company. I mean, King is a big company. Obviously, they were making $2 million a day when they did this. But just big does not mean bad. Corporations are supposed to make money. The people behind those corporations have a fiscal duty or fiduciary duty to make money for the company and do what's right for the company. That doesn't mean murdering the poor. So, there is a line, and the companies need to learn to walk it. But on the flip side, the indie community thinks that they can do whatever the hell they want and scream fair use, and
Fan
you can't.
games are illegal.
Yeah, I mean, the joke memes are illegal started because I've been yelling forever. So I do an AMA on Reddit. I used to every week. I do it more rarely now. I do a podcast every week, though.
He does a podcast called
Noah
Robot
was
Congress.
just on it. Yeah,
It
Robot
is
Congress.
amazing.
Everyone take out your phones, download it, put 5 stars, or get the... No, I'm kidding. But in all seriousness, the questions we answer questions on there now, and a lot of the questions we always get, no matter how many times I repeat it or scream it, is, hey, I'm making a fan game and I just wanted to check that blah 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 were legal, and I don't need to get to the blah 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 because it's not legal. You are absolutely infringing on something. The most common thing that happens is someone says, all right, I want to learn to make games, I want to learn to code, I want to learn art, whatever it is, and hello, and they and they start doing it. Basically they start doing it with the idea of, all right, I love Star Wars, so I'm going to make a Star Wars game. I'm going to learn to code by making a Star Wars game. And they do it, and it was a fun project. They learn to code. They learn to make a cool little game. And then they say, well, this is awesome. I don't want it to just die. I'm going to release it. And that happens so commonly from some kid in their dorm room to a small indie studio with a few members that it's a problem. Disney will sue you. Disney will ruin your life. You don't have any money now? Great. Judgments stay with you for 20 years.
The Magic Kingdom was built on indie dev corpses.
That's right, literally.
Ooh, actually, that sounds really bad.
No, it's true. There's actually a lot of other...
Yeah.
Never mind. But yeah, it's not just Nintendo. I don't know why that became a thing, but it's certainly not just Nintendo. Everyone sues everyone.
Right. For anything, even if they are correct or not. And when you, and we'll save questions for later. We're gonna have it, don't worry. And when
I want to hear it now. No, I'm kidding.
No.
Go.
And when you're out there making your fan games or your fan art, a lot of what we hear you say is, oh, well, I'm not charging for it. It's fair use. I mean, fair use is bullshit. It literally is.
Fair use is not bullshit, but fair use is absolutely something that I would doubt anyone in this room can afford.
Right.
Fair use is a defense, meaning I've been sued. I'm going to go to court and prove I have a defense of fair use, and nothing in the world is fair use until a judge or a jury says it is. And to get there will almost always cost you 6 to 7 figures, and that's a lot of money.
And even then, what you're looking at is you're saying, oh, well, there's this famous dancing baby case. Look it up. It was awesome.
I cannot express to you how many faces I'm seeing look at their business partner clearly, and they're like, fuck.
Welcome to the legal panel. But yeah, so a lot of people will go out there and say, well, I have the exact same case as that dancing baby case on YouTube where this mother was playing Prince and her baby was dancing and it was adorable, and then, they sued her for it. That was found to be fair use.
Right. So Lens v. Universal is the case if you guys want to look it up. Basically what happened is it's the only win in our category. And by saying our, because I rep devs and indies for the most part, the case exactly what Noah just said. Prince was playing on a TV in the background. This baby's getting down. Mom's filming it. It blew up as like, one of the first cute, adorable, dumb baby videos. And
before Vine,
the baby could have been smart. I don't know, but it's but yeah. In all seriousness, so the Universal, who owns Prince's catalog, sued this mother and was like, "Your video is stealing Prince's music." Clearly, the court ran through the fair use factors, which Noah will go over in a moment. You can. I'm giving you time to Google them. No, I'm kidding. But the court went over the fair use factors and basically said, this is the definition of fair use. No one watched this video for Prince. They watched this video for the baby. Prince is on a TV in the background. No one's listening to this instead of a Prince song, et cetera, et cetera, et cetera. And the judge came up with a ruling that is now kind of the rule, where before you issue a DMCA takedown, you need to consider if the other side has a fair use argument. Now, what does that mean for you guys?
nothing.
Literally nothing. It doesn't help you one iota. Do I scream it all the time when I'm defending my clients? Sure.
Yeah.
But it means literally nothing, because anyone can argue, I did consider fair use, and they don't have it. And it's very simple to make that argument. I could on the other side very simply. And that's just the reality we live in now. We're going to have legal changes. We'll have policy changes. But right now, that is the law, and you all need to just kind of understand it.
And when Ryan says you all need to kind of just understand it, I want to take a second and pause because we forgot our disclaimer.
Oh, yeah. We're not your lawyers.
Yet.
Unless some of you I am. We're not.
You I am.
We don't. Seriously, none of this is specific advice to you. Everyone exchanging looks to each other. This might not apply to you for real. Like,
right.
Talk to one of us. We don't charge for consultations. No, or do you?
I do not.
We do not. Do you?
No comment.
All right.
Call us and we'll talk to him.
Yeah. No, but in all seriousness, call us and chat about if you think you have an infringement problem or you think you're doing something that you think is okay that probably isn't. Call us and talk to us about it.
So, talking a little bit more about fair use, the 4 factors, and I actually did Google them because I always forget one of them. It's a different one every time. So, the 4 fair use factors. You ready for some?
Wait, can you name the 7 dwarves?
No, of course I can't. Sleepy?
You nailed it. All right, go.
Cool.
Fair use.
So, the first one, legalese, purpose and character of your use, the nature of the copyrighted work, the substantiality of the work that you have taken, and the effect upon the potential market. So that's a lot of ways, different ways to say that any one of those 4 could trip you up when you come to a fair use defense. And in that one Lens v. Universal case, it was very specifically carved out that in this particular case, with these exact circumstances,
In that jurisdiction,
with these people with that particular DNA, this applies. But to the rest of you, it doesn't right now.
And there's way more cases saying it doesn't apply than the one case that I keep screaming saying it does apply.
Hey, Ryan, what if I'm doing it for free? I'm just releasing for free.
Free does not equal fair use. That is for sure the most common thing we get. Many of you in here don't agree with me, and you're going to continue telling people, oh, no, it's free. It is fair use.
Please don't.
That guy just wants you to hire a lawyer. No. Fair use and free are not the same word. He just went through the factors. Effect on the marketplace is one of 4 factors. So your game, if it's free, but still doing anything that the rights holder doesn't like, whether you're hurting their other games distribution. Look at Nostralis. Nostralis, the World of Warcraft server. Free. Actually, I don't think it was free. Bad example. I don't know. regardless,
So basically, if you're releasing a free game, what a lot of courts will look at, and you'll say, oh, it's free, people are still going to buy the original game. Well, they might not. People might turn to your game and say, oh, this is free. Why would I play, Fortnite? God, don't rip off Fortnite. Why would I play Fortnite when
they're a rip-off.
I know.
Just kidding, I don't care.
Yeah, fuck me. So why would I play Fortnite when I can play, Joe Schmo's Fort Knocked or something like that? And that and that you're still replacing the market for them, so it does affect their sales, and they won't make how much was it? 3 billion, 9 million?
Yeah. It's four factors of differing importance to different judges who do not understand what video games are. They're going to come up and they're going to say, hey, this is some idiot in a manga t-shirt that came and ripped off Disney. He's wrong already in my head, but sure, let's listen to both cases. This kid comes up and says, well, I didn't charge for it, so it's totally fine. He's going to say, you're an idiot, go home, and now you're poor forever. And don't do that.
Poor forever.
Yeah. Really, charging, for sure, if it's free, it's a factor in your favor, but that doesn't mean it's fair use. Right. If it's transformative, that's the other thing everyone's yelling nowadays. Hey, it's transformative. That's great, but it's one factor. You have to get through all of these factors in your favor to a point where a judge or a jury is going to say, all right, you actually have a fair use reason to do this. And I've yet to find a fair use reason that is building your company or business. Right. There's educational reasons, there's journalistic reasons, there's all this other fun stuff. Honestly, memes were for a very long time something you could absolutely say that's fair use. Yeah, I might be building my sweet, sweet karma, but I am just, I'm doing this for fun. I'm making other people laugh. It's fair use. I still would argue memes are fair use despite the name of the panel, right. But Europe disagrees with me, and we can get into that in the Q&A maybe, but it's in 1:30. Are we doing the Q&A now? I talked to
we're going to do Q&A in a couple of seconds because I do have one thing that I always hit on all my panels. It's music. Because one of the number one things I get with music, because music is a weird copyright. How many people do we have out there that create content on YouTube or Twitch or something? By a show of hands. All right, cool. This is for you guys. If you guys are out there streaming music in the background of your streams, your YouTube videos, and
they just Google royalty-free stream.
Don't do that.
Oh.
Please. And don't put no copyright intended, because that's not how it works. You need to have something called a synchronization license in order to put music to your timed motion and pictures and video, and you cannot get that very easily. So you need to go to a rights clearinghouse to get that, or find people such as Monster Cat or 99 Lives. Full disclosure, I actually do represent 99 Lives. That will give you the rights to put that music there. So don't just go say, hey, I bought it on iTunes, or I have a Spotify subscription, because one, you're violating Spotify's terms of use, and two, iTunes gives you a license to play the music, and you don't actually own that music.
Yeah, royalty-free means nothing, just like open source means nothing.
Right.
Creative Commons means nothing, unless you can actually trace it back to the original owner and prove that the original rights owner is granting an open source license or Creative Commons or royalty-free licensing. There's no reason to trust it. It's so easy for a random 14-year-old to take a piece of intellectual property, put it on a different website, and say, this is open source now. Doesn't make it open source. And same with messaging musicians. So many of them don't realize they don't own their music. They sign to a record label, and whoops, I forgot. They say they give you permission to use it. They had no right to do that. The record label will strike your video.
For example, God's Plan. Drake couldn't actually give Ninja the right to use God's Plan because he is one of 53 different rights holders on that song. No joke, actually 53 rights holders. And so the other 52 have to sign off on it as well.
But it's God's plan.
God's plan. Sorry, I'm not Drake.
If you guys have questions, you want to line up on that side so everyone can still see our pretty faces.
Cool. And actually, if this mic is live, you might want to get that set up. I'm actually going to do it myself. Cool.
Noah.
You didn't start it.
No, over there, guys, please, on that side. Thank you.
Testing 1, 2. All right, this mic works. So.
If I can't see Taffy, I get pissed.
I think that's fine. They can just stand right here. All right, first question. Come here. And you can stand wherever you want. Have fun.
All right.
I'm sitting back down.
So my question is whether it's like as a band / composer or for a content channel or a game studio or whatever, when would you recommend looking into trademark and copyright? Because I could see if you think about it too early, then you've spent money and you don't get anywhere. Or if you do it too late, you've already blown up, then that creates problems where people are ripping you off.
If you do it too early, say, hypothetical, doing it too early and you change your course, obviously don't do it without any thought. Think about it first. But if you do it too early and you change your course, you've missed out on maybe $500. If you do it too late and you get screwed to a wall by attorneys or by people who are jerks, then we're talking not $500, but more like $50K to $500K. So that's the cost-benefit analysis you got there. And so I would do it as early as possible. If you're serious about what you're doing, you take the time to invest in it.
Yeah, and it's a budget. Listen, it's always going to be a question of budget. When Sony goes to their boardroom meeting and has 30 different ideas, they trademark all of them with an intent to use, and they know 29 of them will never go anywhere. Yep. But it's just better to have it earlier if you can afford it, and the small filing fee is they're whatever. For you guys, it's a much bigger investment, so you have to take it a little more seriously. You have to be a little more married to the name, but it's never too early because if you wait too long, trademarks take 3 months to 2 years to get, 6 months to 2 years to get registered. So that's a long process, and you want to do it as early as possible. That's not intent to use. That's if you file it upon release, it takes 6 months to 2 years. It still backdates to your first date of use in commerce, but you might find out 2 years later, crap, I don't own this name and I can't use this name. Right. So earlier the better, but it's always going to come down to budget for sure. Yeah.
Thanks.
Thank you.
Thank you. Next question.
A law student.
Yes.
From
My
University
question,
of Richmond.
Yes. My question is about fair use. I know everything you just said, but downstairs they're selling posters and there's fan art and there's fan games. And if I made a game myself and there's I know I made a game and I used open source sound sources, which apparently I shouldn't do. How do you get away with doing that? Is there a rule if you don't distribute it, but you show it to people or post it on Facebook and say, here, play my game, my friends? Or
Yeah, so all of the above, kind of. There's everyone is always going to point to, well, they got away with it. Sega hired that dev team. Why won't they hire my dev team if I make a Sonic game, et cetera, et cetera. The universe has to really align for it to go that well. But to go well enough to sell some posters or an indie game that you're sharing with your friends, the chances they're going to come after you are beyond minimal. But they're still able to. They still could ruin your life. And I'm also, just to clarify, I'm not saying don't use open source. I'm saying just really make sure you know who actually created it. You can follow this stuff. There are many ways to do it. And if it's sketchy or questionable where it comes from, don't use it. It's asking for trouble. But yeah, go.
What I often tell people about, and like I said, always talk to a lawyer before you apply this analysis, but you have a legal risk and you have a practical risk. Your legal risk, if you're making fan art, making fan games, is 100%. Your practical risk depends on how successful you are, and you want to do things to be successful. It increases the more successful you are, decreases the more unknown you are. And so it's really up to your risk analysis and how much risk you can tolerate. So.
Yeah, are you doing it for fun with your friends or are you doing it to be successful? If the goal is to be successful, by the time you get successful, you'll be sued, so don't do it.
So I have another question about derivative art. If you make a game or write a story and you originally make it based off of a known universe or fandom, but then you go back and say, well, I'm going to change all the names and tweak their personalities a bit, does that become fair use?
That's such a good question. I forgot to talk about that. Yes, but there's a line. So if I look at yours and see theirs substantially similar as the test for copyright, confusingly similar as the test for trademarks, still dangerously close. But a really good example is Friday the 13th and Halloween. Both are big, tall, white, doofy serial killers in masks, but they're different masks, they're different serial killers. One prefers camps, one prefers neighborhoods. I don't really watch horror movies, but it's they give me nightmares. No, but seriously, I mean, they are different enough where when you see Michael Myers, you don't think of Jason and vice versa. But on paper, those are so similar. They could have absolutely inspired each other. That's kind of a good line to use as your litmus test.
Yeah.
Cool. Thank you.
Thanks.
I'd like to ask you just to talk some more about DMCA, like especially false takedowns, and we're seeing a lot of that on video game reviews on like YouTube and stuff, and so I'd just like you to expand upon that a little.
So when it comes to false takedowns, honestly, it's a problem, and that's sort of defeating to hear. But when somebody issues a takedown notice and you counterclaim, then you could get your stuff back up. When it comes to commentary, there was a big case that I don't know if anybody here at the table knows anything about called H3H3.
We're not talking about this.
Essentially, it's a rampant problem. Hopefully, there's some legislation coming through. The best way to fight it is honestly to have money, unfortunately, and not everybody can do that. So.
Right. Yeah. I mean, that case was the H3H3 case was cost them, over $100,000. Now
It was crowdsourced too.
Yeah. Well. Yeah. Sure. And then there's more on top of it. I mean, that crowdsource money went pretty quickly. But that's true. They would not have been able to fight it without the community, and you guys aren't all going to get the same community support. The problem is, if you counter a DMCA takedown, you're looking good, and you'll probably be back up within a week or two. But countering a DMCA takedown is quite literally daring the other side to sue you, because the only way they can get you back down is if they bring legal action against you. So if you're doing it against some troll, you have evidence of that, he's not going to sue you. That's usually the right move, general advice for the panel. If it's Sony, be careful. Really know who you're fighting and why.
And there was a lot of UMG coming around too. They issued a lot of DMCAs recently that were completely false, but at the same time, you're daring UMG not to sue you, Universal Music Group. And
they've proven they will sue you.
They will sue the pants off of you, and they'll decide later whether or not it was the right thing to do. So, yeah.
All right.
Next.
Who has a patent question? You get to skip the line. All right, you're next. Come on up.
Who's a what?
Patent.
Oh, good.
So I have two questions. One is, what does the Article 13 in the European Union mean for us in the United States with the Reddit and YouTube and all that?
All right. So this is a great question, and literally the point of the panel that we didn't talk about. Memes became illegal because of Article 13 in Europe that basically said. It didn't say memes are illegal, but you could read it. It's that, and it's because works were so tightly copyrighted that if you are taking someone's image or picture or artwork and writing funny captions on it, that was not fair use. It's absolutely infringing, and now literally memes are illegal. This is another shameless plug, but I'm putting out my next podcast episode on this, and it's 45 minutes of really heavy research from our amazing intern, Caroline. And
that's Robot Congress for anyone who wasn't listening earlier.
Yeah, Robot Congress, 5 stars.
Invite me back.
But it's a really complicated answer. The short answer, which is not legal advice for the panel, is you're fine. Memes I think are the definition of fair use. They're done in a derivative way for sure, but the fair use is a defense, keep in mind. So yes, I'm infringing, but, and I think that this is such a yes, I'm infringing, but that it would be a hard fight to lose. I do think that it's the first of many, many, many bad laws we're going to see, especially from Europe. They're just churning them out. I don't know if anyone knows what the GDPR is. It's not a privacy panel. We won't get into it, but Jesus Christ. They're trying to do the right thing. They're trying to help people. They're trying to help you guys. I mean, the reason these laws are coming out is to protect small artists who cannot afford to litigate and protect themselves, but they get it wrong because they're ancient. They don't know how to open their email. They don't know what a meme is. That's
still
my
use
rambling
AOL.
answer. Yeah.
So my second question is it okay to use things that were found on the free use on Google and use that on a website, and then also cite it on like a sources page that links back to the original source, the data was created, and the copyright owner?
Yeah, only if they're giving permission, which there's a million licenses. If you Google the different licenses from MIT to open source Creative Commons, there's a million different licenses that things are under. And they all have different rules about how you have to give credit. But the problem, like I said, is basically making sure that who's granting that license has the right to.
Yeah, you've got to source in a lot, like Ryan was saying, a lot of people just end up copying stuff and posting it elsewhere. And if they rip off a deadmau5 track and you say, oh, this deadmau5 track, I thought it was a deadmau5 track, but this guy says that it's okay to use, so I'm going to use it here. deadmau5's going to
And that's not super helpful. I know we're just telling you, no, don't do it. Travis, you have been part of more game jams than any human on the planet. How do you find resources that are okay to use?
Oh, man.
Yeah, the mic.
All right, so generally, you
and we're doing a
play
panel
it-
together tomorrow at 4.
Yes, we are. 4 p.m.
4.
in panels 4. Yeah, which is the one before this and on the other side of the building. No, but the gist of it is use your own good judgment. There's a lot of websites out there, opengameart.org and freesound.org, are both excellent resources, but you have to use your own judgment. If you're on freesound.org and you're looking for a bleep and you find something that sounds exactly like the Mario coin noise, maybe don't. But if you find something and the description is what microphone they used and what they did to do it, and you need a little work in order to put it in a game, then you're like, all right, cool. Also, all these websites have options to sort by license, Freesound and OpenGameArt. You can check the box for CC0. The other thing is using asset stores. The Unity, Unreal, and there's probably others out there, all have free assets that are through the store. And so you have a pretty good odds in that case where you're saying, like, yes, somebody put this up. It's Unity's responsibility to curate this because it's their store. You're fine.
And that brings up an awesome point of normally when you hire someone to make you an art asset or sound or whatever it is, you're signing a contract that not only assigns ownership, but they're actually indemnifying you for anything that happens to you. And what indemnification means is I'm giving you something and it's okay to use. If you get sued over it, I will eat those costs. I will protect you. And you're never going to get that with an open source license.
Right.
Correct.
Bam.
Cool.
Thank you.
Thank you. So we've got about 15
Wait,
minutes.
patent question next.
Patent
Yeah,
question.
patent question guy
Zelda
next.
hat.
And we've got about 15 minutes, so we want to make sure we get to all the questions. So
When I was a brand new little lawyer back when we wore suits and coats.
I have a suit.
I wore a suit yesterday.
The senior partner of the firm had we had a copyright issue, and he looked at me. He said, "Copyright's a very complicated, Bill. You know, just know that it looks easy, but it's yes. Hearing all this, it's oh my God. Yeah. Anyway, so hopefully the patent stuff will be straightforward. Go ahead. I'm sorry.
A lot of pressure on me. Okay, all right. So for the patent question I have in particular, what do you have to do to make something differentiate enough that when an examiner takes a look at it, they'll be able to qualify you for the patent? Because there's a lot of things that are out there now that you could build upon, but how far do you have to go? How much do you have to build to really differentiate the product and have a patent qualify?
Wow, the examiner in the audience might smite
right
me down. There's no hard, fast rule. I mean, I usually work with the clients to talk something, because when I write a patent application, we want to preempt those arguments. We want to sit there and go, okay, we know the examiner is going to combine A and B to say, let me think, what was I used to give lectures like elementary school kids. Let me think if I could talk about, actually my son's here. I won't point him out in the audience, but he's here. But so
Raise your hand.
No, oh, there he is.
Hello, yeah.
And so the example I gave is, okay, I made a pin light. Okay, I have a light, I have a pin, I have a light. Okay, and the examiner would say, well, it's just obvious to put a light on the pin.
Right.
And you say, well, you know what? No, because when you put this particular light on this pin, there's a lot of problems. You can't hold it right. It doesn't work. The ink, I don't know, does something weird. The light veers off. The batteries drain. And I solved this little specific problem. That and also, by the way, and it's something called teaching away, that if you could look at the prior art and go, well, if you combine the prior art, now we're getting into legal doctrine. One would not be motivated. That's the key phrase. Would one skilled in the art be motivated to combine the references? Okay, and that's essentially, there's several different things. One is teaching away, render the prior art unoperable, and some other things. The main thing is that you have good backup arguments. So you have your initial claims, maybe you have 5 elements, and then you add a 6th element, and you might have to go add a 7th element. Now, if the examiner starts stacking references, so there's 2 references, 3 references, 4 references, and I've seen up to 5 to 6 references. And then you might have to go appeal. You might just have to go somewhere else to get someone to look at it. But I usually will work with you, for example, quite diligently to get a patent. I like to think every patent application I write is going to get through. Okay, and if you don't have anything there, I'm going to tell you this is what the examiners are going to say. How are you going to rebut this? You might have to go back to the drawing board. The best example I have is I had a small client out of Winchester, and they were doing, now this goes back, IPv6 conversions of IPv4 addresses or something like that, okay? So yeah. So to get their code to work, they had to add 2 patches to the code. That there's no way this conversion would work the way they had it unless they had these 2 patches, and that ended up being their patch.
Because it solved a problem. As long as
Yeah.
it's solving a minute problem that normally combining those 2 elements
yes.
wouldn't do, then it's going to qualify theoretically speaking.
Yes.
Okay.
If it's the end of the quarter, there's all these other things that kind of go into this, but basically, when I write a patent application, I like to have at least 3 or 4 backup plans. But sometimes you're just stuck. You're screwed.
And every time you have to do a rebut to them, it costs money to send in the forms to rebut against their argument.
You pay your lawyer to look at them, so avert your gaze. No,
Are you talking about me to respond? Oh yeah, you're gonna pay money.
Yeah, of course.
But no, I mean, all joking aside, patents can be extremely expensive. Okay, and that's government fees. That's not talking attorney's fees. I'm talking government fees alone. The fee to file a patent application, the government fees are probably more expensive for all of filing a trademark application, attorney's fees.
Isn't LegalZoom cheaper?
No.
Tell us about LegalZoom and patents.
But real quick, we could talk a little bit more because I don't want to take up all the time because I could sit here for 3 hours talking about patent. I would be remiss to not mention design patents. Now, my copyright brethren over here, they don't like design patents probably too much, but design patents are a form of intellectual property. They're relatively cheap. They're still more expensive than trademarks and copyrights. They are a quick and kind of easy way to get some form of protection. Now, a lot of it, these invention promotion scam places, that's what they do. They have you file design patents. A design patent would be, someone said a Coke bottle, right? You know how a Coke bottle looks. You know it's a Coke bottle. You see it, you go, that's a Coke bottle. Okay, you're not patenting holding soda in a plastic vessel. Comprising a top and a middle and a bottom or whatever. It's the design. Okay.
It's curvy.
Yes. Eddie Van Halen. I got him a design patent on his Frankenstein guitar. So yeah.
Sick.
That's awesome.
Yeah. I've yet to meet the man himself or speak to him. I only speak to his whatever guy. But
you don't have to tell that part.
Eddie didn't.
I can't believe you used to party with Eddie.
I had never.
Oh my God, I bet he turns up.
My son's here. Eddie being one of my heroes from my youth. Yes, no, Eddie is like every other client. But anyway, we could talk offline. Be glad to answer questions.
Perfect. And so what we're going to do now is we're going to go into a lightning round. So hop your question up here, and then one of us will answer it, and then we'll move to the next person.
I like this idea of the after dark thing, like 1 a.m. Then we could just sit up here and talk forever.
Get lit.
We're going to do a lawyer panel at 1 a.m. either this year or next year and just get hammered and talk about shit.
Allegedly.
Yeah.
All right.
So I was wondering if I could get your thoughts on the lawsuit from Ferrari to Deadmau5 for decorating it with a Pop-Tart cat, and your thoughts on the Power/Rangers short film on YouTube.
I spent a lot of money on law school, and I know what you're talking about.
Go for it.
No, I mean, I honestly don't know enough about the lawsuit specifics, because I will say to you, when you bring a lawsuit against someone, you throw everything at the wall and you just hope that some of it sticks. And I think a lot of that is what that is. You can sue someone even though you're wrong. You very much might get thrown out for a frivolous lawsuit, but that's super rare. Yeah. So it don't do it, but it is super rare. So these rich companies, they go around and they throw lawsuits out just to make people not do what they want. DMCA trolling on YouTube is a very, very, very poor man's version of those lawsuits, where they say, I don't like this, I don't want you to do it, bam, lawsuit. And that's as specific as I can get without more reading it.
Sounds like a great topic for the Robot Congress podcast.
Yeah. 5 stars, please. Who rates something 2 stars? Like, give it 1 at least. Get out of here.
All right.
Quite a few movies.
I am a part of a streaming group called G1 Game Days, and all the revenue that's brought in, since we're Twitch affiliates, go to the Extra Life Charity Fund at the end of the year.
That's awesome.
And it's something that we've been doing for a while, and we're very proud of it. But the problem, and only a handful of games I've really noticed have started doing this, like Remedy's Quantum Break and the Behemoth's Pit People, they have a streamer or YouTuber-friendly mode where it removes all the copyright music.
That's awesome.
That's great. but not enough games are doing it. So when you play a game like Grand Theft Auto, which is a staple of our channel,
You're gonna get
Rockstar
muted.
has a very elaborate soundtrack. If you turn the music all the way off, it kills the mood. So we basically only can play it once and have it be as presented, but it eliminates any opportunity for any residual income from Twitch or YouTube because all
Do
of
you
those
work
things-
for Noah?
No, I don't.
Because I'm
Alright.
about to plug some stuff.
Please, because any chance we have to make any income for the fund,
Well, let me tell you.
Get
Let me
shut
tell you.
down.
So you've got.
And it's the lightning round, Noah.
Yeah, I know. So you've got Monster Cat, which is an incredible music label. They've got about 1,000
Well,
or
this
so
is
songs.
in-game music. This isn't-
I understand. But built into the Twitch extensions, you've got Pretzel, which is a music player that has about 2,500 to 5,000 and counting songs of all different genres and whatnot. It's sorted for you. You can get a premium version for $4.99, but without the premium version. By the way, I represent Pretzel. And without the premium version, there is a bot that says what is playing in your channel with links back to their Spotify. So it directly supports the artist. Every single thing supports the artist. And it's awesome. And you should totally use it and check out Made Monster because they'd be perfect for that stuff.
okay.
And it literally is meant for that exact purpose.
Okay.
So,
So, like, for the archives of that stuff, is it even worth fighting with
No.
the rights?
No.
Okay, so,
Going forward, though.
okay.
especially not with something like Grand Theft Auto, because the most of the music
Yeah.
groups behind those have already proven they will sue over it. So
Gotcha.
And they'll
it's
sue
just
Grand
not
Theft
worth
Auto.
it.
So.
Okay, cool. Thank you.
But you have a really good charity defense, but
Yeah,
it's
claps
just
for that.
yeah. And what was your channel name again? G1 Game Days. Support them.
Perfect.
Boom.
Thank you. All right. Lightning round question.
Okay, so somebody kind of mentioned this already, but I was curious about just like the legality of the people who are selling like fan art and stuff downstairs, because obviously all that stuff's trademarked.
It's 100% infringing. They're probably not going to get in trouble. Doesn't mean you should do it. If their company really takes off when they're doing it, they might get in trouble. But yeah, I always say fan games are illegal. People say, well, why isn't fan art? Why isn't fan fiction? It all is. But your fan,
It's
you're
just like too small for them to
yeah,
really go
the fan
after.
fiction no one cares exists. And honestly, like I joked about yesterday, Sega went a really different direction than Nintendo famously didn't sue all the Sega fan stuff, because that stuff went a way different direction than the Mario fan art. So Sega was like, no, we're not going to bring headlines to this. But that really is why. So to get sued, you have to piss them off. You have to piss them off enough to call their lawyers, and you have to piss them off enough to file something. And that selling a couple posters downstairs is unlikely, but possible to make that happen.
All right, thank you.
Thank you.
Cool. And while this guy comes up, real quick, audience, is it Mario or Mario? Mario! Or Mario?
Yeah!
Get out. All right. go
Mario! He's literally from Brooklyn. He says, I'm Mario, I'm walking here.
ahead. Oh, my God.
Speaking
I grew up 2 blocks from him, where Spider-Man is.
Speaking of Sega, I had a longer question, but I'm cutting it short. Back in the early aughts, they sued the makers of The Simpsons Road Rage for that game being a blatant ripoff of Crazy Taxi, but they did so under a patent claim.
Well, you woke me up.
So
But we only have 2 minutes, so this is
Go
a
ahead,
quick
go
patent answer.
what I'm asking is what protection does a patent provide that copyright law doesn't provide?
Okay, boy, that's a good question. Okay, patents, yeah, if you own a patent, with copyright and trademark, there is this element of copying, or, I came up with this somewhere else and this other, patents, it doesn't matter. If you came up with it on your own in your garage or your basement and you're violating my patent, you infringe my patent. It's a federal, it's not really, there's no state claims in the patent law area, so it's all federal. You have to hire, to get a patent, you have to hire patent lawyers. You can't hire any lawyer, you have to hire a patent lawyer to prosecute it, not to litigate it. A lot of patent litigators are not patent lawyers themselves. Always keep that in mind. The other thing is, it's probably that you heard all these factors, right? 4 factors. There's 20-something factors with, I think, trademarks. It's all the claim with the patent. It's the claim itself. Now, there's a way to interpret the claim, but it's the claim itself. So it's you can look at it pretty quickly and know where you are and what you need to do.
The Sega case didn't set any precedent.
No second cases, lightning round. Bam.
Yeah.
No, seriously, thank you for your question.
I played Crazy Taxi. Wow.
I drove a Crazy Taxi.
They
Next
patented
question.
the directional arrow.
Oh, yeah.
Yeah.
Hello. Just briefly, your thoughts on the Fortnite dancing case right now? That is a huge question.
Hey, there's a podcast called Robot Congress, and the episode that was out last week is on this.
Yes. So the legal question issue in this case is dancing copyrightable?
Noah got excited, so go, bam.
So
They're probably going to lose on the copyright, in my opinion. However, one or two of them might win on the second and third claims, which are more about the identity associated with the dances themselves.
And so real quick, copyright to protect dance is to protect an entire ballet, not a dance move.
Whole dance.
I think it's going to turn into a policy argument, and the judge is going to change the world. And I for sure, because it's too much money being made that it's ridiculous that those are not protectable. Justice for Carlton.
Hey, I just became an HDMI adopter, and they gave me two different logos, one with the TM and one with the R with the circle around it. And then I go downstairs on all the Samsung, Sony TVs, they have neither. So when do you use which one, and when can I choose not to use
There's no perfect answer. TM is common law. TM is the symbol that means I am either pending registration or I am arguing that I don't need to register. I have trademark rights to this. The R means you're fully registered. It's way more powerful. But it's good defense system for both because most people don't know the difference, so they think both are registered. When you have to use it is a really difficult question because what the law says is not really industry standard anymore. So you see companies using it less and less, and then you see others using it everywhere. I err on the side of use it more and whenever you're using those trademarks, if it's not screwing up and ruining the entire design or layout of what you're trying to sell.
Right.
First off, thank you for doing this in the first place.
Thank you for coming in the first place.
So, long story short, when I was in high school, I was stupid and I made a YouTube channel. It was just a hobby.
Sure.
But my question is, you brought up trademarks, and you specifically said if you're doing this as more than a hobby, you should immediately trademark your brand.
Yep.
We did art assets, custom art assets. I lived in the U.S., he lived in England, but we never trademarked anything because we were never intending to make any money with this. So if somebody does in the future, I mean, this was years ago, but if somebody does in the future come and for whatever reason they like our crappy Let's Play channel that sucked,
I bet
if they
it
start
was
using
great.
our content, are we kind of screwed in that?
Yeah, so listen, the real quick answer, because we're going to get kicked out of here in 20 seconds, is there are no hobbyists anymore in digital media. If you're making an indie game, if you're making a YouTube channel and you're monetizing it, or even if you're not monetizing it and you're putting it out for public consumption, you're doing something that is as risky of being sued and you're as liable as someone making millions of dollars. There really is not a hobbyist world here anymore. And that's unfortunately just the truth. Now, if it's sitting up there from 10 years ago, you're probably fine. But you can have a talk with a lawyer on specific facts. Who's in charge here? Are we allowed to do the last four?
She's in charge. Can we go? Thumbs up or down?
Yay!
All right. Cool. Let's go for it, buddy.
So you talk a lot about ruining your life with this kind of stuff.
Sure.
Should content creators set up some kind of
Yes.
other legal entity like a
Yes.
LLC
Yes,
to reduce
100%.
personal liability?
That is something I always forget to say, and that's a really good question. If you can afford it, set up a corporation, LLC, or anything else, because that makes it so I can't sue you personally. I can sue your company. You have to do it the right way, though, because just setting up an LLC and saying I have an LLC now is not good enough. You have to do it the right way, otherwise a court will pierce that and sue you personally.
Yep. All right.
Quick question. I was just wondering if you could cover the legality of like music remixing, like video game.
Under 30 seconds is fair use, right?
No,
I'm
it's
kidding.
not.
I'm kidding.
If you can understand that there's a beat in it, it does not matter how long it is. If you say I'm taking this part and it's less than 5 seconds, doesn't matter. And a lot of people try and use a fair use argument there. It doesn't work. I would love to talk to you about that after this because that's a really long answer. So we'll talk.
Thank you.
Hello. I was actually wondering what the legality of cosplay is, since it pretty much starts with a visual medium and crosses over into a more physical creative form.
Yeah, I rep a lot of cosplayers, and we. The reality is, I don't think any cosplayer has been sued for infringement, but it's potentially and technically infringing. I literally don't think it's ever happened. But we work with a ton of the top names, and the bigger problem cosplayers have is people stealing their stuff, their Patreon images, et cetera, et cetera. But,
Oh, okay.
Practical versus legal risk.
Yeah.
You're
okay
probably
fine.
You're okay from a patent standpoint.
So real quick,
Thank
that's
you.
our panel. But on social media, you can follow Ryan Morrison at.
I'm Morrison on Twitter.
And I am on Twitter at MyLawyerFriend. And.
Oh my God, I can't remember my Twitter handle. I think it's Nixon at MWZB or Nixon Law or something like that. I can't. I truly
Look 'em
cannot.
up.
Oh, and I have a podcast I forgot to mention. It's Robot Congress.
Thank you all so much.
Thank you for coming.